If you're interested in applying for asylum, but you think, or maybe you've heard that you can't do this because you've already been in the United States for more than a year, then this video is for you. If we're just not meeting, I'm Brian Manning and I'm a political asylum lawyer. I help people from all around the country secure their future in the United States through asylum. And we're going to be talking today about the 1 year filing deadline. And this is, as the name suggests, a rule that says that a person applying for asylum normally needs to do so within their first year in the United States. And if you apply for asylum after you've already been here for a year, then your asylum application is going to be rejected because of that, because of this 1 year filing deadline. Okay. And now this is tough because most people don't know that this rule exists. First of all, a lot of people don't even know that you can apply for asylum, that there exists in the United States this mechanism by which they can ask for protection if they fear being harmed in their own country so that they can stay here. And then if they know about asylum, a lot of people don't know about the rule that says you have to apply during the first year. So lots and lots of cases get rejected because of this. When I was an asylum officer with the government, I saw this all the time, that people got denied because of the 1 year filing deadline. Okay. The good news, there are two exceptions to this. There's two broad categories of exceptions that make it such that it's okay if you file late. If you've been here for more than a year and you file your asylum application, it may be okay. You may still be able to get asylum if you qualify for one of the two exceptions that we're about to talk about. Now, the bad news is that a lot of people don't know about this. Even among immigration lawyers, maybe they know that there exist a couple of exceptions to the 1 year filing deadline, but if they know that, they often don't really know the details and they don't know how it works and they don't understand the exceptions well enough to help their clients benefit from them. All the time, people come to me and say, oh, but other lawyers in the past have told me that I can't apply because I've already been here for a year. But then I talk to them and I learn about their situation. And I say, you know what, actually, it sounds like you might have a chance to qualify for one of the exceptions. And people are surprised to learn that because a lot of immigration lawyers just don't really get this. Okay. So here are the two exceptions. They're called the changed circumstances exception and the extraordinary circumstances exception. And we're going to talk about both of them to see if you might qualify for one of them. All right. So changed circumstances. What is this? This is when something has changed. Something in your life or in your country has changed such that it's now much more likely that you could qualify for asylum, or now more likely that you're going to be harmed or persecuted on account of one of the 5 protected characteristics under asylum law than was the case previously. Now, there are kind of two areas within this changed circumstances exception that I want to talk about with you. One is changes that are specific to you, that have to do with you directly in your life or your circumstances. And to give you an example of this, say someone's here in the United States for 2 or 3 years, and then all of a sudden they become very vocal on social media, for example, in criticizing their government, talking bad about their government, about the party that's in power there, and they're very vocal about it, and they're putting this on all the social media forums. And then they start getting threatened by the government, getting messages from the government saying, hey, we don't like what you're doing. And for example, someone even goes from the government, goes to the person's family back in their home country and says, we've seen what your son has been doing on social media and we don't like it. When he comes back here, he's in serious trouble. So this would be a changed circumstance because in the past, the person didn't really have a reason to fear being persecuted in their country. But now they've become vocal and the government has started to threaten them because of it over their political opinion. So that's a changed circumstance that could allow them to get asylum, even though they're applying for it after having been here for more than a year. So another example of a changed circumstance is when something back in the person's country changes. So this happens sometimes, for example, with laws that come into force. In the context of the LGBT community, we've seen this where a country will pass laws that basically criminalize being gay or any kind of homosexual behavior. And so if someone's here and they're a member of the LGBT community, and even if they've been here for 3, 4, 5 years, if all of a sudden their government back home changes a law and makes a law like this, then that's a changed circumstance. If the government makes a new law and starts prosecuting people under the law and throwing them in jail long term or otherwise harming them, this could be a reason to basically excuse a late asylum filing because the person maybe didn't feel like they needed asylum earlier, but because of this changed circumstance, they do. So let's go on to the extraordinary circumstances exception. This is when there is a really good reason or an excuse basically for someone to not file during their first year here. So Examples of this can be serious illness or mental or physical disability. Basically, if there's something going on that makes your life so difficult and so hard that we can't reasonably expect you to have gotten everything in order to be able to put together an asylum application, put your case together, and file it during your first year, then you could qualify for the extraordinary circumstances exception. Now, note that this extraordinary circumstance exception, the thing that is the extraordinary circumstance, has to happen, has to be affecting you sometime during your first year in the United States. The change circumstance that we talked about earlier, that could be anytime. You could be here 10 years later, something could change and you could qualify for the change circumstance. But with the extraordinary circumstance, the thing that is the extraordinary circumstance has to have existed and affected you at some point during your first year in the United States. Another example of this is someone who is under 18 has what's called a legal disability, and we don't hold this against them in determining whether they are barred from applying for asylum under the one-year filing deadline. It's basically an excuse, and if during your first year you're under 18, then that's not held against you and you can file later. Or also, this is a really important one because a lot of my clients have this. It's called maintenance of status. It's a type of extraordinary circumstance called maintenance of status where you've got legal immigration status. Okay, so maybe someone is here on an H-1B business visa or an F-1 student visa, very common. And you could be here for years, and as long as you had that legal immigration status during your first year, then you might be able to qualify for this extraordinary circumstance of what they call maintenance of status. So really important though, you have to apply within a reasonable amount of time. With respect to the change circumstance exception, you have to apply within a reasonable amount of time after that change occurred, okay? So whatever the thing is that has changed such that you now have a good reason to fear being persecuted, you have to apply for asylum within a reasonable period after that change. And with respect to the extraordinary circumstance exception, you have to apply within a reasonable amount of time after that extraordinary circumstance ends. So in the examples we talked about where someone has legal status, like a student visa, you have to apply within a reasonable period of time of losing that status. So at the end of your studies, when your student status ends, the question is, did you apply for asylum within a reasonable amount of time after that ended? So I've said reasonable time or reasonable period a few times. So what does that mean? Well, that's not defined anywhere. There's no law or even regulation that says what a reasonable time is. We do know, though, from the way that the government interprets this and applies this, that something like 2 months is going to be reasonable. So after the change circumstance or after the extraordinary circumstance ends and you apply 2 months later, that's okay. That's going to be a reasonable amount of time and you will have established an exception to the one-year filing deadline. But when you get past 3 months, 4 months, 5 months, it starts to be more questionable. If you're way out at 10 months or a year, that's not going to be a reasonable amount of time, and your application is going to get denied under the one-year filing deadline. A good asylum lawyer can help you present your case in a way that convinces the asylum officer that you qualify for one of the exceptions, and also that you filed your application within a reasonable amount of time after that. Again, I'm Brian Manning, and it's my pleasure to support you in your asylum journey. Give me a call if you want to talk about this stuff, or leave a comment down below. I read and respond to every comment, so ask your questions or leave comments in the comment box, or give me a call at the number on the screen, and I'd love to do an asylum strategy session with you to see if I can help you in your asylum case.